Right. Good morning and welcome to today's webinar, where we are going to be unpacking the much anticipated and also somewhat controversial employment equity regulations that were published last month. Judging from a recent poll that we conducted among our clients and also from the number of registrations that we got for this webinar, we can see that this is a topic that is keeping many employers, but specifically designated employers, up at night. My name is Chloe Loubser. I am the knowledge and learning lawyer for the employment and benefits practice here at Bowman's. And before we kick off today's webinar, I just would like to run through a few housekeeping matters that will hopefully enhance this webinar experience for all of you. As participants, you are all automatically muted and the chat functionality has been disabled. So should you have any questions, which we do welcome, please make use of the Q&A tab at the bottom of your screen. Those will then be submitted to us and I will pick a few of them to discuss with our speakers at the end of the webinar. Please note we will not be providing any written responses to questions. Finally, this webinar is being recorded and a recording will be made available on our website and also circulated in the next few days. Please also keep a lookout for our further news flashes that we have been publishing on this topic, more of which will come out in the coming weeks. And now let me introduce our speakers. With me this morning to share their views and insights with you, I have two of my distinguished colleagues who are partners in our employment and benefits practice, both of whom have a keen interest and a wealth of combined experience in dealing with discrimination and employment equity matters. First up, we have Melissa Cogger, who is a partner in our Cape Town office. Melissa specializes in employment and data protection law and has a range of experience in the dispute resolution of employment matters, as well as advisory work. She routinely advises on complex employment-related matters, including restraint of trade, retrenchments, transfers, sexual harassment, collective bargaining, protected disclosures, and data protection and equality issues within employment law. She also regularly appears in the CCMA and the Labour Court, as well as in internal disciplinary proceedings. And in 2023, Melissa was recognized as one of tomorrow's leaders by the International Employment Lawyers Organization. Secondly, we have Talita Loubser, who is a partner in our Johannesburg office. She also advises on a wide range of employment and data protection matters, with a particular focus on discrimination law, employee data protection compliance, and the employment implications of corporate transactions. She's acted for both public and private sector clients, and her approach is known for balancing practical business needs with legal rigor and fairness. Talita has been instrumental in advising Business Unity South Africa on employment equity reforms and is a key contributor to thought leadership in this field through her research and publications. Talita has served as an acting judge in the Labour Court and is a published author and co-author on employment equity and contract law. So with that said, Talita, thank you very much. I'm going to hand over to you to kick us off.
Thank you very much, Chloe. Good morning, everyone. It is lovely that you are all joining us. Now, we all know that the Employment Equity Amendment Act came into force this year on the 1st of January. The Department of Employment and Labour has said that one of the key principles of the amendments is to reduce the regulatory burden on smaller employers, those with less than 50 employees, and to, secondly, put in place sectoral targets that the larger employers, those with more than 50 employees, will have to bear in mind when they are setting their targets and that putting in their employment equity reports. The regulations were passed on the 14th of April, and these are two sets. The first set is the repeal of the old administrative regulations and the replacement with new ones and with new forms. And the second is the sectoral targets that are now in place. Now, we all know that there is a long history to these regulations. And Melissa, perhaps you can give us an overview of what happened over the past 7, 8 years or so that we have been talking about sectoral targets.
Thanks, Talita, and good morning to everyone. Thanks for joining us. Yeah, it's been quite a journey getting to these final sectoral targets that were published last month. The first time that we saw the identification of the 18 sectors that we see today was in the draft 2018 employment equity regulations. Those remained in draft form at the time. And those 18 sectors were based on the broad standard industrial classification codes. And they've remained unchanged in the draft 2023 targets, the draft 2024 targets, and now these final targets. Sectors were engaged prior to the Employment Equity Act coming into effect, and whilst it was still a bill in Parliament, those engagements took place during 2019 and 2022. And initially, the sector targets were based on the sector charters that were published under the BBBE codes. And stakeholders were engaged by the department on those numbers. Now, we know that the President signed the Employment Equity Amendment Bill into law on the 6th of April, 2023, but the promulgation and coming into effect of the Amendment Act only came into effect much later. And as you've mentioned, T, that was earlier this year on the 1st of January, 2025. Now, everyone will recall that the first draft of sectoral targets were published in 2023 by way of Government Gazette for public comment. That was also prior to the Amendment Act coming into effect. Then we saw a second draft of sectoral targets published for public comment in the Government Gazette in 2024. And that was also prior to the Amendment Act coming into effect. Then, interestingly, I think as many participants on this webinar this morning may be aware of, there were some mysterious invitations that went out by the department in late December last year, inviting various stakeholders to meet with them on what they called were virtual consultations. Many of these invitations were received on the 23rd of December or on Christmas Eve, and RSVPs were required by mid-January. So a lot of employers were away or shut down for the festive season. And what was proposed in those invitations was to discuss proposed sector numerical targets for whichever sector that stakeholder was engaged in before publishing the final sector targets for implementation. We did attend some of these information sharing sessions that were virtually held in February. We understand that there were meetings held for each of the sectors. And yeah, as I mentioned, it seemed more like an information sharing session rather than a consultation process. A lot of the stakeholders didn't receive the new sector targets ahead of the meeting. So we were not sure what was actually going to be discussed at these virtual meetings. And for many participants, they saw the new 2025 draft targets for the first time in the actual virtual consultations, which were shared on a slide deck. During those virtual meetings, many stakeholders requested time to consider the new draft targets, which were quite different from the 2024 draft targets and the 2023 draft targets. And some provision was made for written representations by various stakeholders to submit their input on those new draft targets. But it was all quite an expedited process. So most stakeholders were only given about 4 business days up to a week to provide written representations. And a lot of those representations pertain to the identification of the various sectors and what the actual sectoral targets were. So those meetings took place in and around February. And thereafter, we're also aware that the department held a number of bilateral engagements with stakeholders. Those were not at the initiative of the department. Those were actually on the request of various stakeholders who had attended the virtual meetings, and they wanted to have an opportunity to make formal submissions to the department on the rationale that underpinned the draft sector targets. And what was explained by the department in those virtual consultations and in the bilateral engagements was that when the department looked at the last reporting period for 2024, the sectors had actually done quite well, and in many instances had already exceeded the draft 2024 targets. And so they thought they needed to be a little bit more ambitious when setting the new draft targets for 2025. And that's what underpinned these new draft targets. And thereafter, as we now know, in mid-April, we were welcomed with the final draft. No, they were not draft targets, the final targets. We were hoping they would be in draft form, but they were in final form. So there was no further opportunity for public participation. And when we consider the draft targets that were shared in the virtual meetings earlier this year, they are for the most part exactly the same as the targets that were finally published by the department last month. So Talita, now that I've gone through in highlight overview this journey that we've been on over the last couple of years, can you talk us through what Section 15 capital A of the Employment Equity Act actually envisages in terms of the process leading up to the publication of final sector targets?
Yes, Section 15A is, of course, an important amendment to the Employment Equity Act. And this section empowers the minister to publish sectoral targets. Under Section 15A, the first step for the minister is to identify the sectors. And it needs to give consideration to any relevant code contained in the Standard Industrial Classification of all economic activities published by Statistics South Africa in determining these sectors. Section 15A, subsection 1, needs to be read with subsection 4, which says that the sectors must be published for public comment for at least 30 days. So that is the first step. Once the comments are considered and carefully so, the DOL would need to publish these sectors, because then the second step under Section 15A is to consult with the sectors and, with the advice of the Commission, then publish sectoral targets and determine these numerical targets. Again, that section needs to be read with Section 15A4, which says that that needs to be published for public comment, not consultation with sectors, for public comment for at least 30 days. Section 15A3 says that a notice may, in which you now set these targets, it may set different numerical targets for the different occupational levels, which we have seen has been done. Also, for different subsectors, or for different reasons within a sector, or on the basis of any other relevant factor. So we have seen in the press that some organizations intend to challenge these sectoral targets in court. There's actually, as we speak, also a case brought by the Democratic Alliance, which is actually quite a historic matter. It comes from, I think, around 2023. We are not going to talk about the prospects of success of those kinds of challenges, and whether the department has in fact complied with the process that is set out in Section 15A. But Melissa, there are two things that we want to flag. and that has come up in the bilaterals that we have attended with clients. And the first is that there are 18 sectors identified. And it seems that they are overbroad. Manufacturing, for example, would include all kinds of manufacturing, medicine, car parts, food, all kinds of manufacturing, retail and wholesale trade, again, very different types of activities. And the second is that there have been changes over the publications of these targets. So if you can perhaps just touch on those points and explain why, you know, those are of concern to designated employers.
Thanks, Talita. Yeah, so as I mentioned earlier, there's 18 sectors that have been identified. And as you correctly point out, they are very broad in nature. And why is that relevant for designated employers? You know, when it comes to what is achievable in terms of employment equity plans, it's going to be different for every designated employer. It's going to take into account, you know, what are the recruitment trends in that particular workforce? What are attrition rates like? What's the pool of suitably qualified people going to be like in that specific sector or subsector? And what are the demographics of that subsector? But if the ultimate benchmark is being made with an overly broad sector in mind, then it might not necessarily reflect the realities of a subsector. And it does bring into question whether these benchmarks that have been set for these broad sectors are achievable and realistic for certain subsectors that fall within the broader subsector. And we know that when preparing an employment equity plan, the objectives that you set out in that plan have to be SMART. So they have to be specific, measurable, achievable, relevant, and time-bound. And we're focusing here on, is it achievable for a specific subsector if it doesn't reflect the realities of that subsector? So examples of various subsectors being put together is, for example, the retail sector. We've got it's the last sector that's been identified. It's the wholesale and retail trade that's been put together with the repair of motor vehicles and motorcycles. As you've also mentioned, a very broad sector is manufacturing. Then we've got other sectors put together where we know that there's concerns, which is agriculture, forestry, and fishing, all put together. And we've got the target set for the top 4 occupational levels based on a single identified sector. It's when you have these overly broad sectors, it's not likely going to capture the distinct nuances and complexities of an individual subsector that falls within that broader classification. And if we also, as you've mentioned, the targets have changed over time. When we look at the 2023 draft targets, the draft 2024 targets, and then now these final targets, there's been a marked increase in how those targets have developed over time. So one example that we've had a look at is the wholesale retail trade and motor vehicle sector. In 2023, we were looking at a draft target for females at top management at about 18.5%. In 2024, that dropped down to 15%, which we presumed was based on public comment that was received in the 2023 draft targets. And then out of nowhere in 2025, top management for females in that sector is at 27.5%. So that's an increase by about 12.5% for females in top management. And you look at the demographics of a sector like retail, which is often quite female dominated, but then you look at it in the motor vehicle industry, which is quite male dominated, then you get these considerations that, is this really achievable for that specific subsector when you consider where they're placed? Overall, we also looked at how the targets have changed over time, and we've also noticed a regression on males as a designated group in various occupational levels at various sectors across the board. So the department's view is that designated males appear to be overrepresented in comparison to females. Now, in terms of the department's rationale, I've already mentioned that they looked at the 2024 workforce profiles. They thought everyone was doing quite well, and so they wanted to be a little bit more ambitious. We've also understood from our clients who participated in those bilateral engagements that there is a little bit of a mathematical equation that the department has applied to these targets. So they looked at the workforce profiles of the sectors, and they looked at the top 4 occupational levels, and they decided that over a 5-year period, it's not ambitious enough for the targets to increase by 1% over each year to get to 5% over the 5-year period. So they decided at top management over 5 years, they want to increase the workforce profile representation by 6%. Then the next level for senior management, they want to increase it by 7%. Professionally qualified, 8%, and then for skilled technical, 9%. So you've got this waterfall effect of 6, 7, 8, 9% over the top 4 occupational categories. And that appears to be the maths and the logic behind these sector targets. What they had mentioned in these bilateral engagements is that this is what they would hope to see as transformation in the workplace and what they think could be done. But overall, and we know because we did participate in some of those virtual meetings, we have represented some of our clients in making submissions and requesting information from the department, there has been quite a lack of information that's been shared by the department on its methodology in formulating these 2025 sector targets. So it's not clear to us whether they've taken into account a multi-year analysis that looks at industry trends, growth, economic cycles, and historical progress on employment equity. And so we don't have any knowledge at this stage as to whether there's been an actuarial analysis that's been undertaken by the department. Now, another interesting target that we saw change in from the 2023 and 2024 draft targets to the current final sector targets is the disabilities target. That was previously set at a benchmark of 2% across the board. And for the first time, we saw it was now increased to 3% across the board. And the department was questioned on this in the virtual consultations. And they had explained that what they want to do is build an inclusive economy. They had admitted that there's no economically active population statistics for persons with disabilities. But in 26 years, South Africa has been hovering at around the 1% mark for disabled persons in the workplace. But the department said that this is because of employers. They're not doing the proper risk assessments to see where they could potentially reasonably accommodate disabled persons in the workplace. And the workplaces need to be more inclusive, and that increase from the 2% to the 3% is trying to take that into account. So T, now that I've given an overview of how we get to where we are at now in terms of the targets from 2023, 2024, what are the options for designated employers and what are their next steps?
Thanks, Melissa. Yeah, many employers are considering the legal route of challenging these targets, but for many other employers, it is simply too costly. And what we are now going to look at is what the next steps are in order to ensure that a designated employer is complying. The timelines are very tight. There is a deadline of the 31st of August this year, and that will relate to compliance with the analysis, the plan, and then the reporting period coming after 31 August. We can take some comfort in what the department conveyed during these bilaterals. The department was at pains to say these are not quotas, these are targets, these are aspirational numbers, and the department wants employers to make progress towards equitable representation. That, of course, is one of the key things that some designated employers are very scared of, that they are going to be measured against these targets as if these are quotas, and that they are not going to be able to obtain their certificate in order to do business with the state, and that they are going to be taken to court for not complying with their obligations as a designated employer under Chapter 3. So, as I mentioned, Melissa, the first step in any employment equity compliance plan is your barrier analysis and the preparation of your employment equity plan. So perhaps if you can just break that down for us a bit so that we understand what the designated employers need to do.
Yes, thanks, Talita. So what is required of a designated employer is to conduct an analysis to identify barriers to advancement of designated employers in the workplace, as well as to do a snapshot of their workforce profile to determine the degrees of underrepresentation of designated groups in the workplace. But perhaps taking a step back from that, in order to get that information to inform the degrees of underrepresentation, you need to collect the information from the employees, and that comes in the form of the employee declaration. Now, in the general administrative regulations, as annexures to those regulations, we have all of the EEA forms and templates. And one of the revised forms is the EEA1 form, and that is the employee declaration form. And there, the employer has to request each employee to complete the declaration. And the changes that we've seen to that specific form now includes the expanded definition of persons with disabilities. So the definition is people that have long-term or recurring physical, mental, intellectual, or sensory impairments. So I stop there on intellectual and sensory impairments is where the change in the definition to persons with disabilities comes into effect. So we have a much broader definition, which may potentially expand the net of disabled persons and might help employers reach those disability targets or get closer to those disability targets. And it's where those disabilities, together with an interaction with various barriers in the workplace, could substantially limit designated employers' prospects of entry into or advancement in employment. The new EEA1 forms also provide a space for persons with disabilities to indicate whether they would require any forms of reasonable accommodation, and then to specify what types of reasonable accommodation might look like for them. So that's not something that we saw previously in the previous declaration forms. And the form is important because it's going to inform a designated employer's analysis and then ultimately the employment equity plan. And other information that's included on the form is, of course, the employee's race, their gender, and whether they're a foreign national. So in our view, it's probably best for employers to do that as a first step. And to ask employees to complete this revised form so that they can have up-to-date and accurate information when they're conducting their workplace analysis and taking their snapshot. And importantly, the contents of that form is confidential. It's only going to be used for purposes of an employer's obligations in terms of the Employment Equity Act. Employees can refuse to complete that form. And if they do, then the designated employer would just rely on reliable historical and existing data, because persons that have disabilities have the right not to declare the disability. And that's specifically mentioned in the general administrative regulations. The general administrative regulations also note that regard must still be had to the relevant codes of good practice, So that includes the preparation, implementation, and monitoring of the EE plan, and then the relevant disability code. And then once you've done those declarations, employers must do their barriers analysis. So in terms of Section 19 of the Employment Equity Act, the employer has to collect information that relates to their employment policies, their practices, and their procedures in the working environment in order to identify barriers that could adversely affect people from designated groups. And in terms of the EEA 13 template, which is for the plan, it says that your barriers and affirmative action measures and analysis must be those that are contained in the template in EEA 12. So there's a new EEA 12 template, which is required to be used by designated employers when they do this analysis and assessment of their policies and their practices in the workplace. And interestingly, that template must be completed because if a designated employer is subjected to a review by the Director General, the new EEA forms say that documentary proof of that analysis has to be in the form of the EEA 12 template. So in our view, it's not good enough to rely on a previous barriers analysis that you might have done in the past in relation to your current employment equity plans. You need to redo the analysis in accordance with that template on the EEA 12 template, which is an annexure to the General Administrative Regulations. And so that barriers analysis looks at whether there's an underrepresentation of employees from designated groups, or if you've got a lack of affirmative action measures or diversity in the workplace. It also wants you to put in practices that have positively promoted employment equity and diversity in the workplace. So if you have a look at those forms, it requires a critical examination of a host of things. So it's going to be your recruitment, selection, pre-employment, promotion, and so on. It's not a closed list, but you must at least complete the minimum information that's contained in that template. And if you have undertaken, more affirmative action measures that are not contemplated there, then you can add in additional rows. So yeah, designated employers are advised to have a look at that new EEA 12 form and to redo their barriers analysis. Then as part of the analysis, they need to consider their workforce profile. So you look at the degree of underrepresentation of people from designated groups in the various occupational levels, and designated employers would compare that against the applicable economically active population, as well as the 5-year sector targets. So you take those benchmarks into account to determine whether there's underrepresentation or potentially overrepresentation of a particular group. Once you've identified the under or overrepresentation of a particular group, then your plan is going to be used to identify and prioritize strategies to address any underrepresentation, which would of course be any of your affirmative action measures that you want to take to try and increase representativity and try and get closer to whatever the applicable EAP is that you're using and whatever the applicable sector target that is relevant. There's also a little bit more guidance on the applicable EAP that you would use. So in previous versions of the regulations, there was a bit of confusion as to whether it was an either or. You have to use the national EAP versus the provincial EAP. But here the regulations state that if a designated employer is operating in more than one province, it should consider the nature of its geographical area and its operations, and then would adopt either the national EAP or the provincial EAP for each of the provinces in which they operate, or the provincial EAP of the province where you have the largest part of your operations. But you still have to have regard. If you're going to use the national EAP or the provincial EAP where you've got your largest operations, you still have to take into account the various other provinces that you are operating. So it's a lot more of a nuanced approach than what was previously seen in the previous drafts of the regulations, and it's a welcome change to this final draft of the regulations. Then they have to choose a sensible date for the snapshot for your workforce profile. So this is your snapshot of how your employees are distributed in the various occupational levels in terms of their race, their gender, and their disability. And this serves as a designated employer's baseline to set the numerical goals and targets for each year in their employment equity plan. So the EEA 12 form doesn't specify when the snapshot has to be taken, but it does say that it would be on the last day of a month. And what we have considered when we take into account when the new EE plans need to be implemented, which is on the 1st of September this year, we're suggesting that clients do their workforce profile snapshot as at the end of April or the end of May, so it gives sufficient time to consult with employees on that analysis and on the preparation and implementation of the EE plan. And then there's an obligation to consult with the workforce. So you need to consult with your workforce on the analysis and on the preparation of your employment equity plan. And all of that needs to take place before the 1st of September of this year. So in terms of the employment equity plan, at a minimum, it would be what's contained in the new EEA 13 template. So designated employers should have regard to that new template. It has to be a 5-year plan, which commences from the 1st of September of this year and will end on the 31st of August, 2030. That plan is going to include that snapshot of your workforce profile that I mentioned. And then it also includes the affirmative action measures that you've identified, whether there's any overrepresentation or underrepresentation that's come out of your analysis. And then you need to set targets with respect to that workforce profile, also taking into account the applicable EAP and the sectoral targets. Now, the Employment Equity Act says at Section 20 sub 2A, which is the amendment, that your numerical goals set by the employer must comply with a sectoral target in terms of Section 15 capital A. So we've had a look at the EEA 13. You would then put in whatever applicable sector target applies to your business, and thereafter you can set your annual numerical targets to try and reach those 5-year targets. So the Act and the regulations are not prescriptive on how you get to the 5-year sector targets. That's up to you. You would take into account your workforce profile, you would take into account recruitment trends, attrition rates, all of that, and you would set your own annual numerical targets. You would set targets for each group, and it's as in previous versions of the EEA 13 template, you would need to set them for each designated group: African, colored, Indian, males, and females. And I think Talita will speak on that a little bit later in terms of how you take those globular figures into the identified designated groups. You would include in that employment equity plan your barriers analysis, your affirmative action measures, the procedures that you're putting in place to monitor and evaluate the implementation of the plan as you had done previously. And then when you're setting your numerical targets, you'd also take into account whatever your inherent requirements of the job is, the pool of suitably qualified people, formal qualifications, and so on. So it's very much in the same way as previously, except for this time, you need to comply with those sector targets. And the general administrative regulations state that you should avoid perpetuating the overrepresentation of any group if that representation exceeds the applicable EAP in a specific occupational level. And, you know, when we're advising clients in the preparation of their employment equity plan, we recommend that you include a detailed analysis and description of what your business is like, what your unique challenges are, what is the specific qualifications and pool of suitably qualified people that you are hiring from that is unique to your specific business and unique to your particular sector or subsector, as well as including and emphasizing the non-numerical affirmative action measures that you're putting in place in your EE plan. So because the employment equity plans have to commence from the 1st of September of this year, it doesn't give designated employers a lot of time. You're going to have to consult on your new plan, probably anywhere between mid-June up until mid-August, then finalize your plan by the 31st of August, and then commence it from the 1st of September onwards. And then, Talita, I've spoken about the analysis, the workforce profile, and the employment equity plan. Can you take us through what the general administrative regulations and the new targets say about the employment equity report and what must be submitted to the department on an annual basis?
Thanks, Melissa. Yeah, that was a mouthful. The report is, of course, very important, and that is catered for in Section 21 of the Act, and it is Form EEA 2 that you need to submit. That form is submitted to the Department of Labour, and there is provision made in the regulations for a submission by hand and an electronic submission. If you choose to do a submission by hand, that submission needs to be in between the 1st of September and the 31st of October of 2025. If you choose to do an electronic submission, you will have from the 1st of September to the 15th of January 2026 to do that. Of course, don't wait until the 15th of January. We've had many instances of clients in the past waiting until the last day and then not being able to submit because the system is just too busy. The EEA2 form, which is the report that needs to be submitted, that is a public document. Simultaneously with submitting your EEA2 form, you are also required to report on income differentials as contemplated in Section 27 of the Employment Equity Act. And the EEA4 form is used for that purpose. That form is not a public document, and that form goes to the National Minimum Wage Commission. So for the first reporting period, from the 1st of September to 15 January 2026, the department and the regulations are saying that employers will not be assessed on progress towards achieving the sectoral targets. This will only happen in the next reporting period. So that would be from 1 September 2026 to 15 January 2027. Upon submission of the report, the department can respond in one of three ways. It can say that the report is not in compliance with the requirements of the Act. It can give you a letter stating that there are errors in the report, or it can give you an electronic communication confirming receipt of the report and that it has been submitted into the systems. If there are errors, then you will be given an opportunity to rectify the errors. Once you have submitted the report, you can apply for the certificate. Designated employers will get a certificate if they are complying with the provisions of the National Minimum Wage Act, if they are complying with Chapter 2 and Chapter 3 of the Act. So that means that you shouldn't have had an arbitration award or labour court ruling that is not subject to review or appeal, in terms of which it is found that the employer has engaged in unfair discriminatory conduct. The employer should also have submitted a legally compliant EEA2 the report. And from the next reporting period, it will be assessed whether the employer is in fact meeting the targets, the sectoral targets. Now, if the employer is not able to meet those targets, it can still get a certificate if it proves that there are justifiable reasons for non-compliance. Those include, for example, that there are insufficient appointment or promotion opportunities, that there are economic circumstances that prevents the employer from making these appointment or promotion decisions, Section 197 transfers that may have an effect on the composition of the workforce after the transfer, mergers and acquisitions, if there are insufficient candidates from overrepresented groups, those types of reasons will be considered. In terms of the Act, it is not a closed list. It seems from the regulations that those are a closed list because it does seem that you need to tick whatever justifiable reason you are relying on. Unless, on the electronic version, you would be able to say other, and that would then enable you to give your justifiable reason. What this means in practice is that you will need to have detailed records of workforce movement in the organization so that it isn't an afterthought by the time that you're applying for the certificate, what the reasonable or justifiable reasons are. But in each decision that this is what my decision is, it may have an adverse effect on overrepresentation in a particular group, but this is the justifiable reason for that, so that you can actually then complete that form. Employers with less than 50 employees do not need to have a barrier analysis and an employment equity plan and submit a report. But if they want to do business with the state, they must get a certificate. In order to get that certificate, the employer needs to confirm that it is complying with the provisions of the National Minimum Wage Act and with Chapter 2 of the Employment Equity Act. So again, no unfair discrimination awards or judgments that are not subject to appeal. And it is therefore very, very important to have measures in place in order to catch these cases before they happen, or to deal with them sensibly once they happen. We are talking about things like sexual harassment and equal pay. It is important for employers to make sure that it has sexual harassment and other forms of harassment policies in place, and that it deals with these allegations swiftly and sensibly once it comes to their attention, so that the employer does not become the subject of an unfair discrimination case as a result of vicarious liability under Section 60. Fair policies on pay, proper job grading, those are important policies to have in place in order to prevent unfair pay discrimination claims. That applies, of course, to designated and non-designated employers. And we strongly advise that you look at those policies and procedures. The certificate may be withdrawn in certain circumstances, such as if it is issued based on a misrepresentation or incorrect information that has been submitted, and that can be done by the minister, by a labor inspector, or by any other representative of the department. Importantly, it cannot be withdrawn unilaterally. and the regulations specifically make provision for the right of the employer to make representations before that certificate is withdrawn. These are the 4 or 5 big compliance items before the 31st of August and immediately thereafter, so until January 2026. But Melissa, there are, of course, other compliance items that designated employers must not lose track of. So if you can just quickly mention those, that would be great.
Yes, thanks, Talita. So there's a number of obligations that previously applied prior to the amendments that will continue. So it includes assigning one or more senior managers that is responsible for monitoring the implementation of the employment equity plan, having authority and the means to perform their functions, and making sure that those managers actually do perform their functions. Then there is the obligation to inform employees of the provisions of the EEA and to place that in a prominent place in the workplace. That's in terms of Section 25 of the EEA. The EEA 3 form has got a useful summary of the Act, which designated employers can refer to, and must also share with employees the most recent report that's been submitted to the department. They must also share their EE plan with employees for purposes of their consultation. So that's both during the preparation and implementation and monitoring phase. And if you are ever subjected to review by the Director General, you're going to have to give proof that you've consulted with your workforce on that. And that includes proof of the composition. If you have an employment equity committee, you know, who comprises of that, what the minutes of those meetings were, what the agendas were, and what the attendance registers say in terms of whether this committee is representative of each occupational level in your workforce, and whether it includes both designated and non-designated groups. And then, of course, employers must continue to maintain their records in terms of Section 26 of the Employment Equity Act. Talita, is there anything from your reading of the general administrative regulations and the new sector targets that's not yet entirely clear? And do we know if and when there's going to be further guidance provided by the department on any issues that might need clarity?
Yes, there are a couple of things that are not entirely clear, Melissa. And yes, we are awaiting further guidance and roadshows by the department. I understand that there have been some logistical issues and that these roadshows are supposed to kick off around about the 25th of May. I think you need to keep an eye out for invitations to these roadshows in your area and attend them in order to obtain further clarity if need be. In relation to target setting, I think there are a couple of things that's not entirely clear yet, because ultimately the employer is required to work towards achieving the EAP. So that is your benchmark towards which you are working. Together with the EAP, we now have the sectoral targets. The sectoral targets are not set with reference to race and gender. It is a globular percentage referring to people from designated groups. So what we would need to do is extrapolate from the sectoral targets what that means with reference to the EAP and what percentage of what race and gender group would then fit within or as we set the targets within those columns. This may require a mathematical calculation, which us as lawyers are not qualified to advise on. But thankfully, in our awards practice, we have a number of mathematicians, statisticians who can assist. So if you need assistance in relation to this extrapolation of the sectoral targets to EAP numbers in order to have a good idea of where you need to set your year one targets, please be in touch. We can put you in touch with our very clever colleagues that can help. Then, if you look at Form EEA 13, which is the Template Employment Equity Plan, it seems to us that your year one targets in paragraph 3 would also be the same as your current year targets. This is because the department wants designated employers to submit baseline numbers. They are not going to assess meeting or whether you are meeting those targets in the first reporting period. That's only going to happen in the next reporting period. So you would then have different numbers in terms of those two paragraphs, paragraph 7 on the one hand, and then the current year targets earlier in the plan. But that seems to be the sensible approach there. We are hoping that that is going to be clarified in these workshops with the department. And then, curiously, the plan template, EEA 13, envisages now that people with disabilities must be reflected in the plan by race and gender. And with reference to the EAP, somehow, this is not the way in which people with disabilities have been reported on up until now. There's been a globular percentage of the employment workforce number that you would say, okay, so many percentage, 1.9%, 2% are people with disabilities, without reference to race and gender, because people with disabilities of all races and genders is a designated group. So this is something new, and we also hope that there will be more clarity on what is required there from the department in these roadshows. I'm sure, as we populate these templates, more questions are going to come up, and yeah, please reach out to us if you have specific questions in that regard. I've said earlier that we can take comfort from some of the things that the department has said in the bilaterals, like these sectoral targets are ambitious, they are stretch targets, they are aspirational, but that's all they are. They are targets. They are not questions. Melissa, for a number of our clients, the issue is enforcement. And how can we know, that what, as a designated employer, we are doing is going to satisfy the labor inspector that comes and does a review of employment equity compliance?
Yes, thanks, T. That is really where we have most of our difficulties and where most of our clients have concerns when it comes to the inspectorate not really applying the Employment Equity Act in the manner in which it's been drafted, or in the manner in which the courts are interpreting, these affirmative action principles. But from what we understand, the department is currently doing a thorough training initiative, in their own words, and they're going to be capacity building for labor inspectors. And the training that they're currently taking the labor inspectors through, which is apparently, according to the media release by the department, is taking place as we speak, is workshops on the implementation and compliance with the amendments to the Act, these new regulations, how the 5-year sector targets are going to work, how the online system works, and how employers can request the certificates of compliance. We can only hope that in those training initiatives and workshops that it is emphasized and reiterated with the inspectorate that these are targets and not quotas, because even prior to the amendments, the way in which the inspectorate was approaching or treating the EAP was almost as if these were quotas and not targets. We also hope that there's going to be emphasis on the justifiable reasons which would excuse a failure to comply, and the fact that both the general administrative regulations and the sectoral target regulations state that there's not going to be any penalty or disadvantage of a designated employer if there is such a justifiable reason that exists. And importantly, for designated employers who are now having this task of compliance, they should keep detailed records of their recruitment initiatives, their promotions and appointments, because when it comes to these DG reviews, designated employers are going to have to justify why they were unable to reach these targets, and they need to have an evidential basis to support those reasons. But having said all of that, the structure of the EEA is still as it was prior to the amendments. There is the inspectorate, there is the DG reviews, but ultimately the fines and penalties that are contemplated in the schedule to the EEA can only be imposed by the Labour Court. So there will ultimately, if all else fails, there will be your last opportunity to make representations to the Labour Court on any justifiable reasons for non-compliance with the sector targets. And as you've mentioned, Talita, there's going to be roadshows by the department. We understand they're going to take place towards the end of this month and during next month. We would encourage our clients to keep their ear close to the ground in terms of invitations to those roadshows. We've attended roadshows in the past and we found them very informative. The department asks and answers very practical questions that come up in terms of how the online system works, how to get your certificate of compliance. And so, keep your ear close to the ground in terms of those invitations and when those will happen. Chloe?
Thank you so much, Melissa, Talita. We have a number of questions that have rolled in. I have answered just a couple of them that had simple answers, and I've grouped together a few of these that I'm going to pose to you. The first one, Melissa, is going back to the analysis and the workforce profile. Someone has asked whether that EEA1 form that you spoke about needs to be completed again by all employees, or is it only new joiners that need to complete that EEA1 form?
Yeah, so the general administrative regulations are not prescriptive to say all designated employers need to recomplete this EEA1 form. It's rather our interpretation of these regulations. And in terms of the regulations, it says that when you're doing that analysis in terms of Section 19 of the EEA, an employer must request each employee in the workforce to complete a declaration using the EEA1 form. And the EEA1 form is the one that's now attached to these new general administrative regulations. And because this EEA1 form differs from the previous versions of the EEA1 forms, including the expanded definition of persons with disabilities, which now includes sensory and intellectual impairments, it would be in designated employers' best interest to actually request all employees to recomplete the new EEA1 form, because it also makes provision for reasonable accommodation, which wasn't something that was previously set out there. And then it also just makes sure that the analysis that ultimately is going to inform your annual targets and what you're going to be reporting on is accurate and up to date and based on information that you've obtained from your employees. Of course, I've mentioned that employees can refuse to complete those forms. And in that case, you could rely on your historical data. When you had new joiners, they completed the previous EEA1 form. You can use that information. But in our view, best practice, because the form has changed and because you have to complete it with reference to the EEA1 form, we would recommend that employers request employees to complete it again.
Thanks, Melissa. And then part 2 of that question was around timing, but as Melissa said earlier on, all of this is informing the snapshot that you are taking of the workforce. And as Melissa said, we would recommend that that be taken, for example, at the end of May. So you would have the whole of May to collect those EEA1 forms to then inform your snapshot at the end of this month. Talita, the next few questions relate to the duration of the plan. And this is also something that we did consider. Someone very cleverly pointed out that the Employment Equity Act itself says that the plan must be no shorter than 1 year and no longer than 5 years. But now we have the regulations that say it must be 5 years. So I mean, what is it? Do designated employers have to now have a 5-year plan, or is there any leeway for them to have shorter plans?
Then that you have a 5-year plan to comply with the regulations, but of course the regulations cannot amend the legislation. And because the legislation talks about no shorter than a year and no longer than 5 years, that should still be an option available to employers. When you are then setting targets in respect of a shorter time period in your plan, you would need to somehow extrapolate those numbers back in order to be sure that you are still going to comply with the ultimate 5-year sectoral target. So I agree that the legislation hasn't been amended. The regulations cannot amend it so that to say it must be a 5-year plan. But if you do that, then you need to be very careful on how you are going to use your 5-year sectoral targets. Ultimately, if your plan is then eventually at the end of August 2030, that is where the sectoral target then becomes very important, that you comply with that target. Well, work towards that target.
Melissa, someone asks, will the Department of Employment and Labour give written approval of employers' plans? So at the end of August, when the plans have now been put in place, will a designated employer be able to get some kind of written approval from the department that it can then show an inspector in the case of an inspection?
Thanks, Chloe. Yeah, there's no written approval that's provided on employment equity plans. The employment equity plans is internal to an organization. So unless you're subject to a Director General review, you wouldn't necessarily be submitting your employment equity plan for approval. What you do submit is your annual report when the reporting period opens, as well as your income differential statements. I understand the regulations as I read them that once you've submitted your report, you will get a letter from the department confirming that you've submitted your report, or you might get a letter saying that there were inaccuracies or various sections might have been incomplete, and you'd be given a period of time to rectify that. But of course, the report is different to the employment equity plan.
Thanks. So let's now go on to a few of the questions about the reports. And Edwin, I see you have done a nice little summary in your question about your understanding of the reports. And it is by far accurate, as you've put it there, other than to say, as Talita mentioned, that your first report is actually, or your first submission is actually this year, not at the end of next year. But then we do come to this conundrum about what is the period that we are reporting on when it comes to this first report. T, you did mention that there was a little bit of unclarity here when it comes to this, but could you just elaborate a little bit more on what we think employers are meant to be putting in this first report that they are going to be submitting when the submissions open in September this year.
Yeah, that is certainly, Chloe, an area of uncertainty. And I see also, that there is mention of the overlap with our current plans. I think what is important is that the department has communicated that employers are not assessed against the targets this year. Then, as I mentioned, from the EEA plan, your year one targets and your current year targets referred to earlier in that plan, they are actually going to be the same numbers. And yeah, it is unclear to me exactly what numbers we are supposed to put in our form. And that is something that we need in our form EEA2. And it is something that we need to clarify with the department. The thing is, when you look at that, that form at the end, it says whether you have justifiable reasons or not, and a confirmation that you are complying with the targets. But, whether that is in fact so, are we going to be at that point if we're only talking about baseline numbers being given and not being assessed this year? So actually, I thought, at the end of that form, there should have been not applicable because this is the year one report, rather than just, are you meeting it or aren't you meeting it, and then having to give justifiable reasons. So, Chloe, you've also looked at this in more detail, but so please elaborate on exactly what we are supposed to include.
Yeah, so I think it's, as you say, Talita, we are now starting afresh. So it's almost as if employers disregard their old plans, but then the question is, what do we report on when it comes to the promotions and the terminations? So it is unclear. And I think this is something that, if not specifically dealt with in the roadshows, is something that stakeholders who attend these roadshows need to pose as questions, because it is very unclear from the regulations what is meant to be there. So I'm hoping that some clarity is going to be provided in those roadshows. Talita, staying with you around these justifiable reasons for non-compliance. Paul is saying, what about where there is a failure to achieve the targets because the business is in a small remote town dominated by a certain ethnic group, and it's hard to attract talent to that small town? How would that be reflected when it comes to the justifiable reasons?
Yeah. Chloe, under section 42, the justifiable reasons are not a closed list. So that would be one of the justifiable reasons that I think would need to be taken into consideration when assessing compliance. I think it is important that that fact about the nature of the business, the location of the business, the pool of potential candidates is included in the employment equity plan itself. And of course, that now opens the opportunity for clever non-numerical affirmative action measures in order to enable employees from underrepresented groups to come and join that employer. So I think things like making sure that you advertise positions broadly and not just locally in the town or in the province, but perhaps in national newspapers or on national radio, or moving away from word of mouth employment, which makes it always a bit, someone and that one will be a good fit. It does still reflect the community that we live in. Those kinds of creative ways to try and bring in employees from underrepresented groups is then also included in your employment equity plan. But certainly, I think on the basis that it is not a closed list, that should be a factor that is considered. I have noted that the form is very much only these are the factors. There actually ought to be a row other, and you should be able to insert that. If it doesn't fit exactly within one of them, I think things like not sufficient opportunities might be one, or economic circumstances might be the one that you would tick, but then explain it very carefully in your employment equity plan.
There have been a few questions around consultation. Melissa, perhaps you can address these. How does one consult? Do you only consult if you have a union in the workforce, or do you have to consult directly with employees? And then when it comes to the sharing of the employment equity plan, if you have an employment equity committee, for example, do you only share it with the committee, or would you share it with all of your employees?
Thanks, Chloe. Yeah, so the consultation obligations come from Section 16 of the Employment Equity Act. And the designated employer has to consult and attempt to reach agreement on various matters, which is the analysis, the preparation and implementation of the employment equity plan, and then the report with a representative trade union that represents the members of the workforce, or if there is no representative trade union that represents members at the workplace, then with its employees or representatives nominated by them. So the Employment Equity Act doesn't specifically say that designated employers must have an employment equity committee in place. But in practice, especially for those employers who don't necessarily have a unionized workplace, the most practical way to meet these consultation obligations is to constitute an employment equity committee, which would be including designated and non-designated groups and across the various occupational levels in the workplace. In terms of the consultation obligations, it doesn't say that you need to share your EE plan with your entire workforce. It must be with those consultative bodies. But in practice, most employers will just share their EE plan on their intranet, and employees can freely access it. It's not confidential information. It does not trade secrets there. You know, these ought to be quite open and transparent processes when it comes to, you know, the demographics of your workplace and what measures you're trying to put in place to address underrepresentation of various designated groups. So I hope those answers the two questions on consultation. Yeah.
Thanks, Melissa. I want to stick with you, and something that we haven't really spoken a lot about, but someone has asked about, is whether there are any direct financial implications for failing to meet these targets, the employment equity targets.
Yeah, so if we look at the schedules to the EEA, there are maximum permissible fines that can be imposed contravening the Act. Those were there prior to the sectoral targets, prior to the amendments. And it includes a contravention of Section 20 and 21, which would include your employment equity plan. And that would include where you would have put in the sectoral targets and your annual numerical targets. So if there is a contravention there, the maximum penalty depends on the number of times you've previously contravened it. So on the worst case scenario, which hopefully this doesn't apply to anyone ever, which would be 4 previous contraventions in respect of the same provision for the last 3 years, that could be the greater of 2.7 million rand or 10% of the employer's annual turnover. But if there's been no previous contravention, then it would be 1.5 million rand or 2% of the employer's annual turnover. So those are the financial penalties that could be imposed. bearing in mind, as Talita's mentioned, there's justifiable reasons for non-compliance. Those justifiable reasons for non-compliance are set out in the general administrative regulations. It's again repeated in the EEA template forms, and ultimately it's only the Labour Court that can impose those fines and penalties. So it would be quite a drastic measure just because an employer hasn't met a sectoral target to be met with this administrative fine and penalty. It's quite a long process. And of course, you're going to be assessed over a 5-year period in terms of those sector targets.
I think that provides some comfort. I know these fines have been publicized a lot, and there's a bit of fear-mongering, I think, going on in the media. So thanks, Melissa, for clearing that up. Talita, there are a couple of questions around group company structures and where do we actually look when we determine whether we have more than 50 or more employees? If we have a holding company that has fewer than 50, but we might have 2 subsidiaries and each of them have more than 50, do we do one report for the whole group or individual reports per subsidiary? Can you just provide a bit of clarity around exactly how do employers actually determine whether they are designated or not?
Yeah, this sounds like an easy answer, Chloe, because you look at legal entity and you look at the number of employees of that legal entity. It becomes complicated when we are dealing with a branch of a foreign entity in South Africa, because that's not actually a separate legal entity. And the question is then, must we include the foreign mothership as well in the numbers? Our view in those circumstances is that you do not, that you look at the South African branch and the employees employed in or by this branch office. Where we have separate subsidiaries, so we have a holding company that is a legal entity and then subsidiaries, it's easier because you look at that entity, who is employed by that entity, and count the numbers. If you hit 50, you're a designated employer. If not, if less than 50, then you're not a designated employer. The regulations make provision for group entities to have a consolidated report. So where there are group entities, it is possible to report on all of these entities that are designated employers, but that must then be supported by individual employment equity plans for those individual designated group entities. Of course, you're only going to do that for designated group companies. But yeah, it is much simpler now that it is simply 50 or more rather than an investigation into turnover. And you might have 25 employees, but this the turnover amount is met, and then you are a designated employer. And I think that is what is meant by the statement from the department to reduce the burden on smaller businesses. Might be smaller in employee numbers, not referencing turnover. So thankfully, we are now looking at 50 or more.
Just to follow on from that, when we are talking about the different categories of employees, so permanent staff versus temporary staff, we see that these forms have a separate box for dealing with temporary employees. We have a question around part-time staff. Are those considered temporary employees, or is it only those employees who are employed for less than 3 months? That's how I understand it, T, is that temporary employees, we are only talking about employees who are on a fixed term contract for a shorter duration than 3 months. Any part-time employees, if they are employed part-time but on a permanent basis, they would be included in your general employee numbers. Is that also your understanding?
That is my understanding. The issue is also Section 57, which deals with labour broker employees. Labour broker employees, irrespective of earnings. So we know that under the LRA, they are deemed to be the client's employees if they earn below the threshold. in certain circumstances. But in the case of the Employment Equity Act, irrespective of remuneration, if those employees are provided to a client for more than 3 months, then they are deemed, for purposes of the Employment Equity Act, to be the employees of the client. And that applies where they are working for the client for more than 3 months. So that is something that we still need to keep in mind. We have raised in the past with the Department of Employment and Labour that this might amount to double counting, because the labour broker may also be counting these individuals. But that hasn't been amended or addressed in any way in the forms, for example.
Lisa, and then when it comes to the compliance certificates, someone asks, how does a non-designated employer confirm their compliance with those other provisions of the Act?
Now, I think you simply say that you don't have any cases against you, because this is an electronic application. So I assume that it would be a form where you tick, yes, I'm complying with the provisions of the Act. I don't have any awards or judgments that are not subject to appeal against me. I'm complying with the National Wage Act, and that can be interrogated. So someone from the department can come and check that you are paying employees above the national minimum wage, and that in fact there are not cases against you. But I think as the employer, as that first step, that is how you would apply for that certificate.
So I think if you could just go back to the EAP and, you know, how to determine whether we're using national or provincial, could you just reiterate the principle there? So if we have a business that operates nationally, but they have employees in the Gauteng province and also the Western Cape, which EAP would the employer use in that situation?
Yeah, I think that question is asking about, if your customer base is national, should you use the national EAP, but you only actually have employees in Gauteng and the Western Cape? Ultimately, you're going to be reporting on your workforce profile of your employees. So it's better to have regard to where your employees are based rather than where your customers are based. And so in that particular example, if you've got offices in both Gauteng and in the Western Cape, you could choose either the national EAP or the provincial EAP for each of those provinces in which you are operating. Or you could choose the provincial EAP where the largest part of your operations are conducted. So if you decide to use the national EAP, or if you do that selection where you use the major part of where your operations are, you'd still need to have regard to the various provincial EAPs. So it's really going to be determined by the nature of your workforce, how your operations are conducted, where the employees are based, rather than where your customers are based.
Perfect, thank you. We do have a couple more questions. Unfortunately, we have run out of time, but we have tried to address as many as we could. I hope that this has been helpful for you. As I mentioned at the beginning, we are running a series of news flashes on this topic. So please do keep a lookout for the further articles that will be published in due course. And of course, if you have any further questions or require assistance in this regard, please do reach out to Melissa, Talita, or any of our other lawyers in our employment and benefits practice. Thank you very much, everyone, and enjoy the rest of your day.